again, if we don't want that in a future ordinance, that could come out. But that's looking at now the question of interpreting what's there. And the question is really in structures for this construction part, I guess really as it pertains to existing structures, and what kind of construction is allowed within existing structures, and how strict we would want to be on that. And I would argue that we wouldn't, in the future, in the end here, with an ordinance, that we would want to allow some exceptions for historic structures, maybe structures built beyond a certain year in the past, certain structures that we would want to look at that. But
well,
for
in the
now,
draft it was prior to 2000, is that correct?
that's what was in the draft.
In the proposed changes.
And that's to preempt the intent to put up an ag structure to immediately convert.
And then to convert it, because we all know the tendency to do that. The ease, we look at it and say it's already there, but I think we see it frequently. I don't know, but you know, the system just kind of now practically encourages that. Well, it's there, we say it's not the best spot, it doesn't meet this or that, but it's already built, and the last guy got to do it too.
Okay, are we ready to make a motion for me to recommend staff's recommendation?
Well, no, we're not quite there yet.
We just had
I concur with Commissioner Wyatt's definition.
So I'd say for now we go with the definition we have in our ordinance of construction, and we leave it at that. If that gets pulled out from the ordinance. Okay.
Commissioner Christian, will I lose this argument too? As I
well,
did with the grade?
this one actually, you know, this is something, a construction issue. I mean, I like the idea, I technically like the idea of things like footprint and that kind of stuff, but I have to say that, you know, I've been on the commission, 8 months now? Seems like forever now. And we've seen 2 or 3 situations already before the commission where there was a, quote, ag building built, and now they're converting it to to visitor uses, and you know, that bothers me. It's like if you're going to be building a tasting room, build a tasting room, put it in the right place, have enough parking, have the regulate, have us look at it, and that's great. I'll approve tasting rooms, but I don't like that sneaky thing, because again, I think there's an expectation by the public that we've got these things to protect us, and then they're being a little bit.
So this is for now for the ministerial permits. It can always be appealed if we want to look at it on a case-by-case.
And it specifically for me goes to the problem of ag conversion, of structures, you know, kind of deliberately. And I think that is happening, and I think, unfortunately, it's going to happen a lot, like in the next 4 minutes. I just, you know, that's the only reason. Otherwise than that, I would want to be, you know, like as Commissioner Wyatt has mentioned, I'd want to pull things out and not have the definition be so strict. But if we're going to just take a look at this and not be rewriting anything, then that's what I'd like to do, be more conservative this time.
So,
yeah, that's what
do you have anything to add, Commissioner?
You're using the year 2000?
No, we're just using the definition in Article 8 of construction.
Oh.
The year 2000 thing is part of the proposed changes for the ag events ordinance that's been kicked up to the board. But for right now, what's being suggested is that we just use the existing definition in the general plan for what constitutes construction.
So if you don't change the footprint, you just change the interior.
No.
Karen, if I can make a couple comments. What we're typically seeing is with the LEM project, which is a great case study for this whole thing, they had an old workshop building. It was not an ag-exempt building. I think it was more of a workshop, but it was an unpermitted structure, and they are getting a permit to convert that to occupancy, change the occupancy on it, and that's required by the building division, and it's ADA compliance is what they're getting into. So they are doing interior remodels only, and they're putting in handicap accessible bathrooms. That was the change. So with that would be the definition of construction, so that would not be allowed if in the direction you're going. Is that correct? So no interior remodels would be allowed.
For now.
For temporary events, I don't see why
you need an ADA compliant bathroom for a temporary event.
You must, if you're using, and it's state law for ADA compliance.
But they have, for example, ADA porta potties, so
Yeah.
there would be options
There-
other than
that is
converting.
correct.
So we're not by this saying
Right.
no ADA bathrooms. You can rent an ADA porta potty for not too much. So
we're talking-
again, it's
yeah.
not a make or break here. There are options.
We are talking about temporary events,
Yeah.
which we're gonna talk about in a
Right,
minute
and
here.
so if you're in
Not-
fact only having your events occasionally, maybe it makes a lot more sense to bring in the porta than to
If you're going to what I consider-
reconstruct your building.
So,
Yeah, I'm sticking to it.
yeah, so, okay, so we're talking, we have at least a majority for the Article 8 definition of construction, which includes no remodels of existing buildings. If you want to use your building
Temporary
as it stands for a temporary event, go ahead and use it, but if you're going to have to, do a major remodel, then that's probably not,
And I just want to point out again, I don't want to see this the case because I think some adaptive reuse
Yeah.
to protect
Absolutely.
historic structures and certain structures is very important.
and to protect the public from having roof
Well,
falling
both,
on them.
of course. And so I don't want to see this stand. I think none of us do because I think we all appreciate the importance of adaptive reuse. But for now, until we get an ordinance through, I think we're recognizing the importance of a conservative approach in thinking this through. So again, I'm hoping we can get the ordinance changed soon
Yeah.
and allow some exceptions.
Thank you for making that point. It's a very good point. We had started to undertake that discussion before the whole thing went onto a different track. So that is something that we are actively discussing, and there will be changes to that. So, okay, so the final item that we need to discuss is the question of whether minor use permits should be vehicles for ongoing multiple events through the years, or whether minor use permits should be used to authorize specific defined events.
I have a question, just a really obvious, simple question that I thought I knew the answer to, and now I've gotten confused, and that is, do minor use permits run with the land normally?
Yes,
Okay, so normally a minor use permit just runs with the land, and there isn't any question about it expiring upon a change of ownership or a change of use, or, I guess with a change of use, yeah, but, no change, okay.
That's true, but a minor use permit is
I'm just
typically issued to build a thing. You get a minor use permit to build a tasting room
Well,
or...
I'm just asking the question.
Yeah. So, who wants to jump in?
Well,
On
here's
that
where, the reason I asked the question, of course, is because if you look at the land use ordinance, and it says that temporary events need a minor use permit, and then you look at the language from the 1992, and it says your length of it is, 12 days, or consecutive days, or 4 weekends, or through a minor use permit. My question is, was the intent to allow that minor use permit to be applied to that use and on that property in perpetuity by just saying, okay, it needs a minor use permit? And believe me, this is one of those ones where I would wish that I would say that I would not want them to run these types of use permits to run with the land. I'd like to have some kind of control over it, if only for enforcement's sake. But my reading of it says that under our current policy and our current the current reading of it says, yeah, I mean, if temporary events were basically by definition supposed to have a minor use permit, and minor use permits run with the land, then the implication is that the minor use permit, that the minor use permit is supposed to run with the land in perpetuity.